Good evening, everyone. I am Kriti Sharma from Team Taxmann, and I welcome you all in today's live webinar on the Bharatiya Nyaya Sanhita 2023 and overview. But before we proceed, I shall take this opportunity to briefly introduce Taxmann. We are India's leading publisher of tax and corporate laws, committed to offering our users the most authentic and enriching experience. Our goal is to simplify the research and compliance for the legal community. And now, everyone, please welcome our esteemed speaker, Professor Vageshwari Deswal. She focuses on criminal law and gender justice, renowned for her contribution as an academic, author, feminist, and activist. She has made significant strides in her field of expertise. She enriches academic discourse and actively engages with broader societal issues, reflecting her commitment to justice and equality. Before we begin, here are a few tips for the audience. Your mic will be on mute during the session. However, you can post your queries in the chat box provided. The speaker will answer your query either during or after the session. A copy of the presentation will be sent to you via email for future references. So without further ado, I would request the speaker to address the audience. Over to you, ma'am. Thank you.
Hello, good evening, everyone, and welcome to this webinar on Bharatiya Nyaya Sanhita 2023. Now, this is a new law, and we've all been eagerly awaiting the notification that when this law is to be implemented. Fortunately, a few days back, we got this notification, and now it will be implemented from 1st July. So, during the course of this session, we've got around 40 to 45 minutes. I'll try to highlight the important changes that have been brought about in our substantive criminal law by virtue of this law. So first of all, let us try and decode the title. Okay, from Indian Penal Code, which was drafted by the Britishers in 1860, we've come a long way. Now it is the Bharatiya Nyaya Sanhita of the year 2023. See, the title, it was Indian. And section 18 of the Indian Penal Code defined India as territory of India excluding the state of Jammu and Kashmir. Post abrogation of section 370, now we don't need any such kind of an explanation because India is self-explanatory. The entire territory of India, now no state needs to be excluded from the application of this law. Then it was Indian Penal Code. So the usage of the term penal, what this implied was that the objective of law was to punish. See, that was a law which was enacted by our colonial masters to keep their subjects in check, so as to punish any transgression of the law which was laid down by them for their subjects. Whereas this is a law which has been enacted by a democratically elected government for its people, and that is being reflected in the title when it says Nyaya. Okay, so this is more of a justice-oriented law. Although when we'll go through the provisions of this law, sometimes we feel that maybe we could have done a little more in upholding this promise of law, of doing justice to our people. But still, so far, so good, the changes that have been brought about, that are laudable. So, see, when we talk about the substantive criminal law, see, there is a query by Mr. Chirag Shah. I will be taking the queries at the end of the session. Okay. So, the law, criminal law, which was the Indian Penal Code, the focus was more on punishment rather than doing justice. And in the criminal justice system, see, punishment to the accused does not necessarily translate into justice for the victim. Victims are largely ignored in our criminal justice system. So when we look at these three laws comprehensively as a whole, you will see that there are many areas wherein victims, they have been given some sort of a say. So that is the shift from punishment to justice, and Sanhita, the literal translation is code. So now the short title, commencement and application. So this is applicable throughout the territory of India. The notification for its implementation has also come, and now it will be implemented from 1st of July 2024. Rest It is almost the same. The jurisdiction is the same. We have the territorial jurisdiction, extraterritorial, admiralty, personal jurisdiction. It is all there. But what are the exceptions to applicability of Bharatiya Nyaya Sanhita? Again, it is the same as was in the IPC. That is, it does not extend to punishing mutiny and desertion of officers, soldiers, sailors who are employed in the service of Indian government. Why? Because they are dealt with in accordance with the provisions of Army Act, Navy Act, and the Indian Air Force Act. And they are not applicable in case there is a special law or in case there is a local law, which is applying only in a particular part of the country. So this is a law which has been laid down in 358 sections. Earlier, the IPC was divided in 23 chapters spread over 511 sections. So now we've made it crisper. Now we've got 20 chapters consisting of 358 sections. Now, how have they done this? Like when we come to the short title, commencement and application, now it is there in only one section. Earlier, it was spread over from sections 1 to 5. Then definitions and general explanations. So they were spread out from section 6 to section 52A. But now there is a separate section for definition, section 2, and in section 3, all the general explanations have been covered. Then coming to punishments, now we have covered all the punishments in just 9 sections. Earlier, they were spread out from sections 53 to section 75. Similarly, in abatement, for criminal conspiracy, we had a separate chapter. For attempt, there was a separate chapter. But now they have all been clubbed together in one chapter, which is chapter 4. Similarly, offenses against women and children, they were scattered over various chapters. We have them in chapter 16, 20, 28, and also in the last chapter. But now they have all been clubbed together, and there is one single chapter which is dedicated exclusively to all crimes that might be taking place against women as well as children. Punishments, again, we have retained all other punishments. Transportation for life, that was already done away with by the Criminal Laws Amendment, by the first Criminal Laws Amendment Act after our independence. Besides that, all other punishments are there. Same, it is like death, imprisonment for life, imprisonment which could be rigorous, which could be simple. Then there is forfeiture of property, fine. And there is one additional kind of punishment that has been introduced, and that is community service. By introducing community service as a form of punishment, we've tried to bring in certain principles of restorative justice. Then there are certain offenses for which death penalty may be awarded. By and large, they are the same for which we had death penalty in the IPC. Some new provisions have been added to this list. One important change here is the mandatory death penalty, which was provided earlier under section 303. That was struck down by the Supreme Court in Mittu versus State of Punjab. That was a 1983 judgment. The courts had held that mandatory death penalty is unconstitutional, so it was struck down as void. But the provision was still there. The legislature had not done anything regards that. So now when we have brought in this new law, so that mandatory death penalty, it has been done away with. Then there is this new kind of a punishment that is being provided nowadays, and that is imprisonment for life, which shall mean the remainder of that person's natural life. See, this kind of punishment was for the first time introduced post-Nirbhaya in the year 2013, when we brought in the Criminal Laws Amendment Act. But now this has been added to many, this is now being applied to many other crimes also. See, one cause of concern here is that when we say that life imprisonment shall mean the remainder of that person's natural life, what that implies is that we've taken away the discretion of the state to commute the sentence. Okay, so that has been taken away, but the power of pardon, which vests in the governor and president, that is above the legislative act. So that is the only option now available to a person who has been awarded this imprisonment, which is further qualified by the phrase imprisonment for life, which shall mean the remainder of that person's natural life. So now this person, he cannot claim to be released from prison after 14 years. The state cannot exercise their discretion. It's not for the Home Department anymore. Then the next is community service. So community service, it has been defined in the Bharatiya Nagarik Suraksha Sanhita as work which the court may order a convict to perform as a form of punishment, because the objective would be to benefit the community, for which the accused or the convict shall not be entitled to any kind of a remuneration. See, this is a form of non-custodial restorative justice, and it is an attempt at re-socializing the convict. So it is a way of reformative punishment. See, this is something which was already being practiced by in many jurisdictions, such as in Delhi. I know there are certain courts which award, like in case of traffic violations and all, people are asked to man the traffic for some days, or people are asked to perform some seva in the Gurdwara for some days. So this is something which was already being employed. So maybe now we will broaden the ambit. There'll be maybe more kinds of community services coming in. So now this is a very, very progressive and a positive step. And this has been introduced by the Bharatiya Nyaya Sanhita in only some very petty offenses. Okay. And then again, it is for the discretion of the courts. Then changes in terminology. So certain terms, they have been changed. Like earlier, we used to use this term minor, which was like when we were talking about cases of kidnapping, when we were talking about rape of a minor girl, when we were talking about procuration of a minor girl for purposes of trafficking, prostitution. But now this minor term, it has been replaced with child. Okay, so this is a very progressive term. We are talking now child, because what happened earlier when we were talking about minor, we had different age which we had fixed. In cases of kidnapping for boys, it was 16, for girls, it was 18. Then coming to a minor married wife, it was 16, it was again 15, but otherwise the age of consent for prosecutions of rape was 18. So now they've made it one single uniform age, which would be 18 for all children of all genders. Then this term gender, earlier the pronoun was like he, and it would also include references to men as well as women. But now it includes references to men, women, as well as trans persons. So now this is a very welcome change, which was much required, since now we also have the Transgender Rights Act, Transgender Persons Act in 2019. So at least now we've acknowledged them to be human beings, to be persons. So now they are finding a place in our laws also. Then another very welcome change in the terminology is regarding the definition of movable property. Okay, now movable property, it includes property of every description. Now, this is a definition which would have an impact on the definition of the offense of theft. Because earlier theft, when we would talk about movable property, the term movable was restricted to only corporeal property. We were not talking about incorporeal or intangible property. So then that law was somewhat lacking when we were talking about offenses such as data theft. So now, with the definition of movable property expanded to cover also incorporeal property, this is a welcome change, very contemporary, much in tune with what this changing times require. However, there is one concern, and that is regarding retention of the phrase outraging the modesty of woman. See, after the Nirbhaya incident, when Verma committee was constituted to suggest changes in our criminal laws for safety of women, they had recommended non-penetrative sexual assault to replace this old terminology as to what constitutes modesty of a woman, what would amount to outraging the modesty of a woman. Moreover, in 2012 itself, we had got the gender-neutral POCSO. Now, gender-neutral POCSO uses the gender-neutral term sexual assault in place of the term rape or outraging the modesty of a woman. So now in 2023, when we were enacting a new law, maybe now the time was right to have ushered in this much required change also, because this term outraging modesty of woman, again, it appears very archaic. Then let us talk about certain more changes or additions in the law. First, there is a new provision that has been introduced by virtue of Section 48, that is abetment outside India for offence in India. See, earlier we had a provision 108A in which abetment in India for offence outside India was already a crime. And the illustration that was appended to that section, as per that illustration, if somebody in India abets the commission of a crime in the state of Goa. See, mind you, at that time, Goa was not a part of our country when IPC was enacted and that provision was introduced in the IPC. So that was it. But now what they have done, they've taken cognizance of crimes which might be abetted outside India. So this is now, the law is now more comprehensive in its coverage by insertion of Section 48. Then coming to this offense of marital rape. We all know that rape is rape, whether it takes place within marriage or outside marriage. See, we cannot say that a husband cannot rape his wife. The only thing is when the husband commits a forcible sexual intercourse with his wife, he is not punished by, because he is protected by the marital rape exemption, which is provided under the IPC. We continue to retain that. But what has changed is, see, in 1860, the age of marriage for girls, for the husband to avail benefit of this exemption was 10 years. Later on, it was raised to 12, then 14, until 2020, till 2023, this age was 15 years. When we brought about changes post Nirbhaya, what we had done, we had removed the window of 12 to 15 years. See what the law said earlier, that it would not be rape if the wife was above 15 years, it would not be rape if the wife was above 15 years of age. If she was between 12 to 15 years of age, then punishment would be only for 2 years. And if it was, she was below 12 years of age, only then the husband was punishable with a higher punishment. In Independent Thought versus Union of India, 2017, Supreme Court struck down this exemption clause, this age, which was provided under the exemption clause of 12 to 15 and only 15, whereas for the rest of the girls it was 18, as being unconstitutional and arbitrary. So now whether a girl is married or whether she is not married, the age of consent would be 18 years as per that Supreme Court judgment. So now that judgment, it has been incorporated in the law. And now what does this exception say? Sexual intercourse or acts by a man with his wife, the wife not being under 18 years of age is not rape. So now it is not that a man can rape his minor wife if she's above 15 years of age. No. Now there is a uniform age, whether the girl is married, whether she's unmarried. Below 18, no one can establish physical intimacy with a woman, even if he's married to that woman. Then there is a new provision that has been introduced, and that is Section 69, which reads sexual intercourse by employing deceitful means. So, see, if you will go in details, by and large, the significant Supreme Court rulings, they have found a place in this law. Because the changes that were recommended by the judiciary, but it behoves for the legislature to actually bring in those changes. So now what the legislature has done, mindful of the judicial decisions, they have brought about these changes. And this is what has happened. Now, this is a law which incorporates the Supreme Court judgment of the year 2003 in Uday Singh versus State of Karnataka, in which the courts had clarified these things. That see, when a woman, if she has consented to an act, now why was the consent given? Whether the consent was given because the man had promised her marriage. So here the test is, if the man did not intend to keep his promise, if the man had made a fake promise, a false promise, so if the promise was fake from its very beginning, then it would amount to rape. Otherwise, just in case the man is not able to keep his promise at a later date, then maybe that would not amount to rape. So that is again something which has been brought in by Section 69, and it says sexual intercourse by employing deceitful means, whoever by deceitful means or by making promise to marry to a woman without any intention of fulfilling the same. So here again, what would be the crucial part of understanding this section? Without any intention of fulfilling the same. So it means that the intention to nor keep the promise should be in existence at the time when the person makes the promise. So then it would amount to an offense under section 69, and the explanation says deceitful means shall include inducement for or false promise of employment or promotion or marrying by suppressing identity. So any kind of deceitful means that have been exercised on the woman to get her consent, whereas the man has no intentions of keeping his promise at that time, then those would be the cases that would be covered under this section. Then there is another new provision, which is hiring, employing, or engaging a child to commit an offense. Now, this was another much needed provision, especially after the changes in the Juvenile Justice Act in the year 2015. What happened in the year 2015? Post the Nirbhaya incident, there was so much of clamor that maybe we need a separate category of juveniles who can be tried as adults in case they are on the verge of attaining majority. So we created a separate window, that is, the Juvenile Justice Board will decide in cases of heinous crimes. Again, they define heinous crimes also, that is, offenses which are punishable with imprisonment of more than 7 years. So in such cases, what can be done? A minor can be tried as an adult also. See what happened after that. Suddenly, there was such a surge in crimes being committed by minors who were on the verge of attaining majority. What happened? People started employing minors as agents to commit crimes because the minors would then be let off with a maximum imprisonment of 3 years. And see, manipulating of birth records and all that is also not very, very difficult in our country. So this was a law which was very much required to tackle all those kinds of problems. And now what it says, whoever hires, employs, or engages any child to commit an offense shall be punished with imprisonment of either description, which shall not be less than 3 years. Again, see, there is a shift. Now we are prescribing minimum punishment in case of such serious offenses, but which may extend to 10 years also. There's an explanation also, which is much in conformity with the provisions of POCSO also, because it says hiring, employing, engaging, or using a child for sexual exploitation or pornography is also covered within the meaning of this section. Then punishment for murder. This is section 103. Punishment for murder is provided under section 103. Earlier it was provided under section 302. Now there is a new clause which has been inserted herein, and it says when a group of 5 or more persons acting in concert commits murder on the ground of race, caste, or community, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or with imprisonment for life, and shall also be punishable with fine. See, for murder, we already had this punishment. And murder, when it was committed by a group of 5 or more than 5 people, we would invoke the principles of joint liability. We would invoke section 149. Additionally, section 34 was also available for common intention. So with the help of common intention, with the help of 149, we could impose a joint liability, and all the people who were involved in the act would be punishable for the same offense and would be entitled to the same punishment irrespective of the actual part that was played by either one of them, because that is the basis of joint liability. But see, there was this judgment of Supreme Court in Tehseen Poonawalla case to 2022, wherein the Supreme Court asked the state that we need to make some provisions to curb these crimes of mob lynching, because it is very, very important to uphold the rule of law. So people must be scared of punishment under the law when they are doing crimes such as mob lynching. Similarly, when we talk about hate crimes, when we talk about honor killings, so honor killings, hate crimes, mob lynchings, now all these kind of crimes, people were clamoring for separate laws. Although we already had provisions for that, but now, even if we are talking about separate law, so all that has been taken care of by this one singular clause, 103 clause 2, which imposes joint liability in all such crimes. Then causing death by negligence. Again, So that was, we already had this provision in section 304A, but what are the changes that have been introduced herein? One, see, punishment may extend up to 5 years. Earlier it was only 2 years, now it may extend up to 5 years. Second thing is, if such act is done by a registered medical practitioner while performing medical procedure, so now this is something many doctors, they are concerned that maybe this would make medical negligence criminally punishable. See, the concept of negligence, the jurisprudential concept of negligence is by and large covered under the civil law. To bring it in the ambit of criminal law, what has to be proven is that there should be a mens rea, that negligence, that want of due care and precaution, it should be done by someone in a way that no other reasonable person, reasonably placed person in his place would have ever done. See, when it comes to imposing criminal liability on doctors for medical negligence, so we already have guidelines which were issued by the Supreme Court in Jacob Matthew versus State of Punjab. That's an old judgment, but a very significant judgment. I think that's a 2005 judgment. Okay, that's 1 minute. That's 2005, Jacob Matthew. That's a very important judgment in which the courts had said that we have to safeguard against mindless criminal prosecution of doctors. So what is required is that this has to be further certified by a board of doctors, whether the doctor, what the doctor has done, he is liable, criminally liable for medical negligence, or whether it would be a case which would sufficiently be covered under civil law, under law of torts, as well as under consumer law for medical negligence. So that is something, that judgment would still prevail. We have this law, but the application of law, it would always be done in the light of that Jacob Matthew judgment. Thereafter, another contentious provision in this is clause 2 of section 106, which talks about someone who runs away after causing death, after committing an accident which is of so serious that somebody might die because of that accident. Now, why did we need this kind of a clause? Is because as per the NCRB data of the year 2021, persons killed in hit and run cases were more in number than persons who lost their lives to murders. So this is something which was very much required, but the implementation of this particular clause, it has been put on hold in wake of the massive protests which were done by the lobby of truck drivers and all, because see, they have their genuine concerns. What they are saying is that in case we would stop to help the victim, or in case we would stop to register an FIR or inform the magistrate, maybe in that time the crowd would catch up with us. Maybe we could be subjected to mob lynching or something like that. But then see, we have provisions in the BNSS now, zero FIR. It has been introduced as a provision in the law. Another thing, e-filing of FIR, that can also be done. But still, this is something maybe we require more time before we implement it fully, and that is why the notification which has come regarding the implementation of these 3 laws, it has put the implementation of this particular contentious clause on hold for the time being. Then coming to organized crime. Now, this is another new definition which has been introduced, because so far we did not have any central law relating to organized crime. We had so many state laws, like we had this in Maharashtra, in Gujarat, Andhra Pradesh, Arunachal Pradesh, Karnataka, Telangana, Uttar Pradesh. So there were so many laws, so many states which had their own laws relating to organized crimes. But till date, we did not have any central law. So now we have a central law. In this respect, there are 2 important phrases regarding this. One is continuing unlawful activity and one is organized crime syndicate. Now, what does the law say? Any continuing unlawful activity, including. So you see, when they use the phrase including, so this is the list of unlawful activities that has been given herein. This is merely illustrative. This cannot be interpreted to be an exhaustive list. Okay? So there is scope for judges to interpret it in a wider way. Because see, laws, they exist for the society, and laws, they need to keep update with the changing needs of society. So 100 years back, no one could have imagined that the kind of cyber crimes that are happening today could ever happen. And at the pace at which the society is growing, at the pace and the pace at which AI has made inroads into our law, into our lives, I mean, you don't know what are the new kinds of crimes that will soon crop up. So that is why it says continuing unlawful activity, including, to be merely illustrative, it could be kidnapping, robbery, vehicle theft, land grabbing, contract killing. But the only concern here is BNS nowhere has defined these terms land grabbing, contract killing. So there could be a lot of discretion with the prosecution and judges regarding interpretation of some of the terms that have been mentioned herein. Okay, then it is talking about the organized crime syndicate. Okay, when we earlier got this bill in August, it was talking about minimum of 3 persons that were required. But now it says a group of 2 or more persons who acting either singly or jointly as a syndicate or gang indulge in any continuing unlawful activity. So again, that organized crime syndicate, it has also been clearly defined. And continuing unlawful activity is any activity prohibited by law, which is a cognizable offense, punishable with imprisonment of 3 years or more. So you see, they could not have mentioned all the titles of crimes in the definition. So what they've said, all cognizable offenses which are punishable with imprisonment of 3 years or more. But then again, what is required is that it should have been done by any person, either singly or jointly, as a member of an organized crime syndicate or on behalf of such syndicate in respect of which more than one charge sheets have been filed before a competent court within the preceding period of 10 years. And the court has taken cognizance of such offense and includes economic offense. Now, some people have concerns that what would happen because we already have state laws now with the coming of a central law. So would there be jurisdictional issues and all? So see, there would be no jurisdictional issues as it is, because the constitution is already very clear that in case of any repugnancy, it is the central act which has to prevail. So as it is, there would be no problem. In any way, there is no repugnancy also, because the definition of organized crime, it has borrowed heavily from the definition of organized crime, which is there in the state legislations. Then petty organized crime. See, that was organized crime. Now, when that organized crime is of a less magnitude, see what has happened in this new BNS, that depending upon the gravity of the crime, the punishment has been decided. So in case the organized crime is there, but not of that magnitude as would be covered under section 1111, then it is in petty organized crime. And what it says, whoever being a member of a group or gang, either singly or jointly, commits any act of theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting, gambling, selling of public examination question papers, or any other similar criminal act, that would be a petty organized crime. Now again, further it clarifies that for the purposes of this subsection, theft would include trick theft. Now again, trick theft, it has not been defined anywhere. Theft from vehicle, dwelling house, business premises, cargo theft, pickpocketing, theft through card skimming, shoplifting, and theft of ATM. So this is again a very welcome inclusion in the law, something which was much required. Then coming to Terrorist Act. Again, when we talk about Terrorist Act, so we already have UAPA, Unlawful Activities Prevention Act. So this is a special legislation. And special legislations, they work in conditions that are different from ordinary conditions. Therefore, special laws are created with the objective of addressing these special situations. For this, a new legal structure is established. Special laws deal with new offenses and also provide special investigative and adjudicatory procedures to be followed in the prosecution of those offenses. Therefore, provisions of CRPC, to the extent they are inconsistent with the special provisions of UAPA, are inapplicable to prosecutions under the statute. So you see, when we already have a special law, What was the need for this provision? Now, that is one query. And then people, they are concerned also about misuse, because see, under UAPA, for any prosecution, you need sanction from the appropriate government, from the appropriate government. But here in IPC, in BNS, that could be done away with because we are not talking about sanction. So here, this explanation clause, but it has clarified, okay, to be on the safer side, that any officer not below the rank of superintendent of police shall decide whether to register the case under this section or under the UAPA. So both these laws, they will exist side by side. To my mind, despite having a UAPA, why we have introduced this provision in the BNF also is because I feel maybe that was done because as per the title of the law, it is Bharatiya Nyaya Sanhita. So instead of merely punishing the accused in the UAPA, because see, UAPA is a special law, the general exceptions that are available under the BNF or which were earlier available under the IPC, they are applicable in cases of special crimes in a very truncated form. Whereas all crimes that are given under this, they are available, they are all subject to those general exceptions that are provided herein. So there could be a discretion with the courts to see how much of punishment is to be awarded to the accused person. And then the definition of terrorist act, okay, I've not given it here, but the definition of terrorist act is again the same as is given under the UAPA. Then another provision which is voluntarily causing grievous hurt, it was already punishable under the IPC also. But what is the change that has been introduced here in that? See, a person commits voluntarily causes a grievous hurt to a person, and the grievous hurt is such which causes the victim to be in permanent disability or in a persistent vegetative state. So in such crimes, what we require is a higher punishment for the offender, and that is what has been taken care of under the BNS. Similarly, when we talk about people acting in concert in a group of 5 or more than 5 people, and they cause grievous hurt to a person, again, the gravity of the crime increases. And such offense, it warrants a higher punishment that has been given under 117 clause 4. Next is sedition, which was given under 124A, sedition, which was Rajdroh. Now it has been changed, and now sedition as it is, it has been removed. Instead of Rajdroh, we have brought in treason, which is Deshdroh. This is section 152, which deals with acts endangering sovereignty, unity, and integrity of India. One thing is, sedition was a strict liability crime. So, irrespective of the intention of the accused person, a person would be held guilty. But this has been made subject to mens rea, and that is clear by the usage of terms purposely or knowingly. See, because as I said, this is a law which has been, this is a provision which deals with somebody doing something not against the government, but against the state of India. So here we've brought in this concept of mens rea also. It should be done either purposely, it should be done knowingly. It could be by words, either spoken or by signs, visible representation, or by electronic communication. Now, this is a new addition, by means of electronic communication, because so much is happening online. But then again, this is a cause of concern because as per the Telecommunications Act of 2023, see what if, because the state can, of course, if it is required, telecommunications do information which has taken place over this, what we will call it, this telecommunications, the state can gain access to that if required. And this would exactly happen when charges of treason would be leveled against a person. Even in absence of concrete evidence, our right to privacy could be compromised by virtue of this provision. So this is something which needs to be taken care of. I'm sure the courts would be handling it, and we'll have to wait and watch for some decisions to come to see exactly how the interpretation and application of this provision unfolds over the years. But then again, this was something the courts had directed the states to take certain actions to deal with the offense of sedition, and the Union of India had already admitted before the Supreme Court that they were looking into this, and that is why they repealed sedition, and in place of that, they have brought in this provision of treason. Then, so again, this is an explanation. The explanation is the same, which was retained in sedition in view of Kedarnath Singh versus State of Bihar. It says, comments expressing disapprobation of the measures or administrative or other action of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite the activities referred to in this section do not constitute an offense under this section. Then again, these are some provisions which have been introduced. If a public servant who's doing his duty, especially when he's suppressing a riot, and in that situation, if somebody assaults or obstructs, and then there would be a fine. And the minimum fine, and that too, the amount of fine, it has been fixed. It would not be less than 25,000 rupees. See, earlier in IPC, the fine that was prescribed was 50 rupees and 25 rupees, that kind of a fine, which would not have a deterrent effect in today's time. So that has been taken care of here. Then attempt to commit suicide, section 309. Now, after we got the Mental Health Care Act in 2017, there was an implied repeal because it said that people who try and attempt to commit suicide, they require some sort of a treatment or assistance or counseling instead of penalizing them. So that has been taken care of. And as it is, we were not having any prosecutions or any convictions under 309 because that was just a token kind of a provision which provided a maximum punishment for 1 year. But in most of the cases, whenever somebody would be actually held guilty, the courts would give them punishment such as imprisonment till the rising of the court. So that was the kind of, it was just meant to be an educative and a provision so as to deter people from committing these kind of crimes. So as it is, that has been removed. But now what we have is, if somebody attempts to commit suicide to compel or restrain a public servant in the exercise of lawful powers, then that would be punishable. Again, the punishment that could be, it could be a term of 1 year, it could be just a fine, or it could also be merely community service. Then snatching, which is already an offense in states such as Haryana and Gujarat. Now this has been made an offense under the central law also. Then additional clauses, they have been inserted in section 324 and 341 with, the punishment for defamation, which could be, see, although we've retained defamation as a crime, in most of the countries, defamation is just a civil offense. We have retained it as a crime, but the punishment could be, it could be imprisonment, it could be fine, it could be both, and it could also be only community service. Though now earlier we did not need this clause of repeal and savings because IPC was a new enactment. BNS has been enacted to repeal IPC. That is why we needed this provision, so as to clarify that actions taken under the IPC, they would remain as it is. But because see what happens, criminal law, they are always prospective in operation. We cannot apply them retrospectively. That is why this is something which was very much required. So these are the changes that we've already discussed. These repeals, definition of India has been omitted, sedition, all this. Then the definition of thug. We never convicted any person under that. So that has been repealed. Section 377, unnatural offenses. After Navteej Singh Johar judgment, 377 was not decriminalized in toto. We had merely watered it down so as to take out consensual unnatural offenses out of this ambit. Consensual intimacy between two people was taken out of the ambit, and it was only non-consensual activities which were punishable. But now by repealing this, on one hand, we claim that this is a law which has brought in some sort of a gender neutrality, some sort of a presence to identity to trans persons has been given, but by total repeal of 377, this appears to be a somewhat regressive action, or maybe it has been an oversight on part of our lawmakers. Then 497, adultery, it was already repealed by the Supreme Court in Joseph Shine judgment. So now that has been done away by our lawmakers also. Some concerns, although we have removed adultery, But enticing or taking away or detaining with criminal intent a married woman with intent that she may have illicit intercourse with any person, again, this is such a colonial and an archaic provision. The husband has, the husband has all powers over his wife. The woman's consent is of no significance here. We are not talking about a woman who's a minor. We are talking about fully grown adult women. Now, when we are retaining these kind of provisions, so removal of adultery, it is like doing just half the job. 84, it should not have been retained in the BNS. Then coming to causing miscarriage. The law which was enacted by Britishers in 1860, in toto, we have reproduced this provision without caring for the changes that have been brought in about by the MTP Act. And then 377, I've already talked about this. And then again, when we talk about right of private defense, assault with intent to gratify unnatural lust is a ground for private defense in full measure. But once sodomy takes place against any wife or man or trans person, the law is not going to do anything about it. So, right of private defense is available. But when it has all actually taken place, we are not going to do anything about it. Similarly, sexual offenses against animals. Bestiality was taken care of in 377 of IPC, but now since we've removed it, so again, that is one area wherein maybe we need some law to take care of. Then, moreover, we need more clarity in actually defining what constitutes defamation, obscenity, outraging the modesty of women, and all. So that would be a very brief presentation. Now the floor is open for questions. I can't hear any questions. Do we have any queries? I don't know, maybe. Do we have any questions? See, if you can ask any question, please go ahead because I can't hear anyone.
There are few questions. Let me just. As the judge decided what type of punishment should be levied, how the decision will be taken, is it on circumstances or on the case depth, either punishment or fine or both? How will it be justified?
No, this is something which was already there. See, there is always a discretion which is to be exercised by the judges, but this discretion is again, we have certain, safeguards against unburdened discretion. See, depending upon the facts and circumstances of each and every case, depending upon the aggravating and mitigating factors, here we apply the test of the crime as well as the criminal. So that is why there is a discretion which is vested in the judges to see whether it is an offense which has been committed in a manner that we should award the maximum punishment that has been prescribed for that, or maybe we can lower the sentence, or maybe it is something for which mere fine would suffice, or it is so serious that it would require both punishment as well as fine. So again, something let the judges take a call on this.
Ma'am, another question is, do we need to study old CRPC or new BSS?
See, the law will be implemented from 1st July. So in case you have exams before that, if it is for a student or even if it's for lawyers, till 1st July, the old CRPC will prevail. After that, it will be a new one.
Would community service amount to forced labor since any national service is the only exemption from Article 23?
It would not amount to forced labor because it is a punishment. See, even otherwise, when we talk about punishment, which was earlier prescribed under IPC, so we had a couple of judgments wherein we said that when we are asking our prisoners to work in prisons, so maybe we should give them some sort of a minimum wage. But then again, it is a human rights issue. It is not a legal right. They have violated some legal rights of some other persons. They violated the laws of the country for which they are being penalized. So if the state decides to give them some minimum wages, that is well and good. But when community service is a kind of punishment, there would be no money whatsoever that would be given to them because that has been specified in the law itself. And that is not unconstitutional.
Okay, ma'am. We have one question from Madhur Gupta. What changes can be made to prevent the misuse of Section 69?
See, Section 69, I mean, there's a lot of alarm amongst people because they have not gone through the language of 69 very carefully. See, what it is saying is that there should be intention or knowledge, as I said, the intention to cheat at the time when the person had promised that thing. Okay. So, unless and until it can be proven that the person wanted to cheat from the very beginning, if later on the person goes back on his promise, there could be any reasons, then 69 would not be invoked in such cases. But if the person uses that promise as a pretext to gain consent without having any intentions of fulfilling that promise, it is in those cases that 69 would be invoked. We already have those Supreme Court judgments to further guide us in this direction. This will not override those judgments.
We have a question from Sudhanshu. Is there any change for dead body rape also?
Necrophilia, no, that is not given here.
How is the provision in terrorist attack of BNS differ from UAPA and the provisions of MCOCA?
See, MACOCA deals with organized crime. The definition is the same. Similarly, when we talk about UAPA, the definition of terrorist activities is the same. That is just a special law. This is the central law. We've also covered it. As I said, I mean, only time will tell whether covering terrorist act in BNS was a good step or not. Because as I said, when we talk about UAPA, I mean, general exceptions are not applicable therein. I mean, even if they are applicable in a very restricted format. Whereas crimes in BNS, they are subject to those general exceptions. So that allows us to take a more lenient view. Now, if that was the objective of our lawmakers, then it is right. Otherwise, inclusion of terrorist activities in BNS, maybe we have just diluted the BNS. Fortunately, there is one provision which says that we have to see whether the case is to be registered under the UAPA or the BNS. And that is which the superintendent of police will take a call on. Maybe that is some saving grace therein.
Okay, ma'am, Rashi has a question. Is it really necessary to define age criteria in case of marital rape? How age makes a difference in such offense?
See, marital rape as it is, we need to criminalize it. But then again, lawmakers are concerned that maybe there would be a misuse of the law. Okay, that is why we are holding back. But at least see from 10 in 1860 to 18 in 2023, we've come a long way. So at least we are protecting minor wives against this. But of course, I agree that a lot more needs to be done.
Mr. Deepak has questioned, in your opinion, ma'am, now that the government has decided to bring the laws in operation by July 1, does that give enough time for the entire criminal justice system to be aligned with the new laws, especially considering that these laws overhaul the entire scheme of criminal laws to which most of the participants of the system have seen during their entire lifetime?
See, Deepak, most of the important changes that have been brought about in the BNS, we could cover in almost an hour's time. Okay. Similarly, if we talk about BNSS and BSA, okay, the changes that have been brought about in those two laws, basically those two laws, they exist to supplement the main substantive law. Okay. So all the related provisions, see, what we've tried to do is make it more contemporary. Like after the Information Technology Act, we had introduced some provisions in the IPC, like when we were talking about electronic communications and all, also that was introduced there. And in 2013, again, we changed. So what happens that there were just piecemeal changes. And when you look at the overall body of changes, there is not much that has changed. So till July 1, but till 1st July, one who actually wants to know all that has changed, there is sufficient time.
We have a question from Ravi Sitaraman. Tell us something about compounding of punishment fine.
That is something which is taken care of under the Bharatiya Nyaya Sanhita. Now, in that, there is a list of compoundable, non-compoundable offences, and what are those which can be compounded with the permission of the courts, without the permission of the courts. So, again, that is something over which we cannot apply our discretion. When it comes to compounding, see, compounding is a legal term. And what cases are compoundable, what are not? We have to go by what the law says. For that, BNSS has a table.
Mr. Ravi has also questioned whether 66A stands repealed.
What 66A?
Yes.
Let me see. 66A was relating to. Let me just see. Did we have any 66A? That was punishment. I'm not sure. I haven't seen this provision. What is 66A? Sara, IPC tips pe nahi hai. Sorry, I can't answer this.
Madhur Gupta has questioned, should it have been gender neutral then?
Which offense are we talking about?
Madhur, please let us know which offense you're talking about. Let us address another question.
Even Adib, I see by and large, BNS is gender neutral. You know, we are talking about both men and women. There are a special category of crimes that are against women for which we have this. You know? So our rest all crimes are gender neutral.
Dr. Vijaypal, will BNS help to curb the crimes in comparison to IPC?
It's more about the agencies that are entrusted with the responsibility of curbing the crimes. People have always committed crimes and they will always commit crimes. Okay, it is how well the laws can be implemented and whether the laws, whether there can be a scare in the minds of people that if you violate the laws, you will be prosecuted. Okay, there won't be any exit point. So till the time there is not this kind of a fear, till the time our police, they are not well equipped and they don't do their duties the way they should be doing, I don't think till that time merely enacting of a new law can control. See, we've had laws since 1860, IPC, crimes have always taken place. The same will continue after BNS also. Let us see how well they can be implemented and how effectively they can be. Okay. So you are talking about IT Act. That is already there. This will not have any overriding effect on that. That was Shreya Singhal judgment. That has already been deleted if you are talking about that. That has already been deleted. That is IT Act.
We have one more question. Will false promise to marry amount to rape or not? If a person has ill intention from the beginning and had made sexual intercourse with a girl by
then
giving...
it would be a rape. That is something that the law makes it very clear. Self-explanatory, the provision is. Okay. Now, Deepak Parashar has one more question, 498A. Okay, quashing of petitions, inherent powers of the court that are to be exercised by the courts. See, there is no change. The law is the same. Okay, the only thing is in the scheme of the section is that the definition of cruelty was included in 498A, but now the definition of cruelty, it has been put in a separate section. That is it. Nothing else. Another question, the cases that are already going on, but cases are decided. See, what is the relevant test is the date of commission of crime. If a crime is committed before 1st July, it would be subjected to IPC. On 1st July and after 1st July, BNS will prevail. Because criminal law, it is always prospective from the date of implementation.
BNS is prospective before July CRPC.
BNS, CRPC is BNSS. That will also be implemented from 1st July only. See, whether an act amounts to a crime or not, that is something that BNS decides, because that is the substantive law. So if your act is a crime, if you do something which has been declared to be a crime under IPC, but it is not a crime under BNS, but if you've done it before 1st July, you would be prosecuted. Okay? But then what happens in such cases? Courts, they usually take a lenient view. You would be tried for the crime because it was a crime on the date of its commission, but the courts then usually they take a lenient view because see, adultery, it was a crime earlier. Okay, after 2019 now it is no longer a crime because it has been decriminalized. But for a person who has committed this act before that judgment it came into operation, people, they would be still continue to be tried, but the courts, they obviously exercise their discretion and they take a lenient view in such cases. That is what happens.
Okay, ma'am, I think we have, you have answered all the questions, you have answered all the queries. So shall we go ahead and end this session?
Yes, please.
Okay, so thank you so much for your outstanding presentation and a clear and concise explanation of the subject matter. We greatly appreciate the effort that you have put into making this session a success. I would also like to thank the participants for their cooperation and contribution. We could have not done it without you. Although we have attempted to address the queries raised during the session, please feel free to send any additional queries in writing to sales@taxmann.com. Thank you all again. We look forward to presenting another vital topic to you soon. Until then, take care and have a wonderful time. Thank you so much.
Thank you, everyone. Thank you.